episode, we'll look back at one of the biggest industrial disputes in Australia's history to date. In 2011 to the start of 2012, Qantas Airlines was locked in a battle with unions representing pilots, ground staff, as well as engineers over pay, work conditions, and outsourcing, which ultimately led to the grounding of all flights and the lockout of staff. The unions that were involved and supporting the staff of Qantas were the Australian Licensed Aircraft Engineers Association, ALAEA, the Transport Workers Union, TWU, as well as the Australian and International Pilots Union, AI. On the 23rd of August 2010, AIPA canvassed its members to discuss changes to the enterprise agreement, as concerns were raised after talk of Qantas wanting to employ overseas pilots for lower rates. Following this, in February of 2011, the enterprise agreement that ALAEA had with Qantas was terminated. New claims were then pursued, including equal wages across all job types as well as job security provision. In March 2011, ALAEA applied to Fair Work Australia seeking approval for industrial action such as strikes, work halt meetings, as well as elimination of software control, all in which were illegal. By May, unions claimed that the negotiation with the airline had hit a brick wall. ALAEA members stopped work for half an hour in the afternoon and an hour and a half in the morning and refused certain duties. Days later, Fair Work Australia granted their application for protected industrial action as well as enterprise agreement between Australian Service Union and Qantas, applying to 7,200 administrative staff. Following this, the AIPA commenced their protected industrial actions, with pilots making in-flight announcements to passengers regarding their diminishing job securities, an action that was illegal deemed by Aviation Australia. In August, Qantas announced a major restructure of their job units, which included the termination of up to 1,000 jobs. In rebuttal to this, TWU proposed 3,800 members take 4-hour work stops. Shortly after, Qantas alleged acts of intimidation against the non-union workers due to work bullying such as death threats, car damage, and more. With this back and forth battle, Work Relations Minister Evans voiced his concern of the bitterness of the dispute. In the same month, Qantas cancelled scheduled flights and grounded 5 aircrafts. This was all done legally as it is in reply to industrial actions. The Prime Minister at the time, Julia Gillard, issued a statement saying, "Qantas and the relevant unions are saying they want to negotiate this dispute. Well, I think they should get on and do it." Then, the day of the boldest decision came. On the 29th of October 2011, CEO Alan Joyce announced the grounding of all Qantas domestic fleets. He stated that the lockout would continue until relevant unions dropped their, I quote, "extreme demands that have made it impossible to agreement to be reached." 2 days later, Fair Work Australia then terminated all industrial actions at Qantas under Fair Work Act 424. This resulted in a 21-day time of bargaining. During this time, the Senate Rural Affairs and Transport Legislation Committee sought evidence from Mr. Joyce regarding his crazy decision to ground Qantas fleets. In November, the AIPA challenged Fair Work Australia's decision to terminate industrial actions in federal court. Qantas and the unions failed to reach an agreement within the prescribed 21-day time frame. This is when Fair Work Australia had to step in and sort the issues. Though the month following, Qantas and the ALAEA were able to come to an agreement of a 3% wage raise, job certainty for existing engineers, but A380 maintenance was allowed to be conducted offshore. The new year then clicked over, and Qantas announced an entire restructure of their operations in hope to improve efficiency. As a result, approximately 500 positions were lost, ranging across engineers, cabin crew, catering staff, pilots, as well as ground staff. All was done in a legal manner. With all these actions taking place, the legality of these came under speculation. Regarding Qantas and Alan Joyce's decision to lock out those who were threatening to strike was a necessary action to communicate the severity of the actions in which the unions were taking, and to enable them to deal with it sensibly. The locking out of staff breached no laws. Threats made by ground staff, engineers and pilots regarding pay, as well as the outsourcing of jobs too fell under and complied with Fair Work Commission. Though it can be said that the actions undertaken by the unions were unlawful, due to talks of death threats, bullying, as well as damage made on employees' property that were not taking place in the strike. These unlawful acts are a breach of Fair Work Act 2009. Aside from the millions of dollars Qantas lost each day, this dispute had a big impact on the wider community in 2011. Qantas held 65% of the domestic airline market and 15% of the international market. As a result, up to 80,000 passengers were affected on the first day alone by the dispute's actions. Passengers all around the world were stranded in different countries. Opposition airlines saw the advantage to offer all Qantas passengers discounted flights to their destination. Due to the extent of the grounding, the significant damage to the national economy, especially with regards to tourism and mining sectors, were affected immensely. Australia's GDP of the year of 2001 had a noticeable drop. This is a result of lower profits for companies, thus causing lower stock prices. The GDP is an indicator to determine whether an economy is in recession. Furthermore, the tourism industry leaders say the Qantas dispute has threatened to ruin Australia's credibility as a tourism destination. Daniel Gutschwin from Queensland Tourism Industry Council said, "The conflict has gone on far too long now, causing enormous collateral damage to everybody." This dispute also cost Australian tourism $80 million over the weekend the planes were grounded, leaving the economy to suffer $250 million loss per day. There were employees that suffered as a result of this incident too, though were not involved with the dispute, such as ground workers, Qantas reception staff, as well as the cleaners that worked at Qantas boarding areas. Furthermore, suppliers of Qantas are left without clients, such as catering companies. Without ongoing flights, these side companies are left in the lurk. Due to a failed 21 days of negotiation, Fair Work Australia had two decisions, to either suspend or terminate all industrial actions. It was said that suspension would only put a halt to the actions and would continue to represent a threat to the airline industry, as people would be uncertain when booking in the future. Fair Work Australia then agreed that all actions taken by both Qantas as well as the involved unions were to be terminated immediately, and they settled all agreements across the whole dispute. As seen, this dispute has a major upset with Qantas as well as the wider community. Industrial disputes such as this must not be a regular occurrence, as not only does it affect the companies and unions involved, though it can stretch out to the wider community, such as the economy, people, and industries. Furthermore, industrial relation laws must be altered in order to prevent or even stop disputes such as this from happening. Workplace relations spokesperson Adam Brandt pushed for change, though nothing came of it. Brandt suggested the introduction of a new bill that would close loopholes in the Fair Work Act. The bill's actions were to give 3 days notice of a lockout or any change in normal operations, allow Fair Work Australia, when deciding termination protected action, to have regard to whether it considers that the purpose of the lockout was to make any applications more likely to succeed, and to ensure termination of any protected action that brings threat to the economy, health, or welfare of the population. Another recommendation is the implementation of communication strategies allowing stakeholders to be informed and notified via meetings should any industrial actions take place. This will greaten the efficiency of negotiations to be achieved. Qantas and this ongoing dispute has caused major collateral damage by affecting not only the companies and the unions involved, though the wider community too. Changes must be made to prevent industrial disputes with nature such as this from occurring. Thank you for joining 60 Minutes. That's all for tonight's show. I'm your host, Gav Underhill. Have a great night.